All right. So, hi, a very warm welcome to everyone. Very good morning and happy Sunday. Once again, it's really wonderful to meet everyone who has joined for this wonderful cause of discussing legal education related topics, all academic discussions. And it's a sincere gratitude towards all the distinguished guests and faculty members who choose to take on the responsibility on a Sunday morning to help enlighten all of us with respect to various developments and various issues related to law and all such topics. So those who have been coming here are aware that such and such initiative has been going on for such and such number of years now. It feels good to say that, but at the same time it only feels better to know that there are such and such more number of brilliant people who are out there who are working every single day for this noble profession to help raise legal literacy, at the same time to be able to contribute to the betterment of society. So for one such lecture today, we have with us Miss Mohini Priya. She is an advocate and an advocate on record of the Supreme Court of India. Briefly speaking about her, she is also a trained mediator and is certified by the Mediation and Conciliation Projects Committee. She has passed out from the prestigious Government Law College, Mumbai in the year 2009, and since then has been in independent practice. He has done some prominent work in the fields of constitutional law, medical legal law, service laws, media laws, NDPS Act, and in the field of intellectual property. Some of her recent works include challenging the discriminatory and restrictive regime brought about by the Surrogacy Regulation Act 2021 and ART Act 2021. About this, we'll get to know more from ma'am today. Apart from that, she has also challenged some arbitrary and erroneous requirements imposed by states for a kidney transplant under the Transplantation of Human Organs Act 1994, challenging the dilution of the Juvenile Justice Act, amongst others. She believes that law is a truly noble profession and an impactful lawyer is one who strives to bring out a social change, and her work profile is wholly a reflection of that philosophy. She has also done substantial work with NGOs such as Prayas and has been relentlessly working for women and child rights, socially backward classes, student bodies, transgender rights, animal rights, and environmental protection. She is also a policy advisor with India Child Protection Forum, headed by Nobel laureate Mr. Kailash Satyarthi. Apart from that, she has also authored several publications and has appeared in various um, legal interviews, so to say. But amongst other things, all of these things probably we'll have more opportunities to discuss with ma'am. But for right now, ma'am, I very warmly welcome you to this session today, and I hand over the class to you.
Thank you so much. Thank you so much for the introduction. Should I start now? So I would
just for the record, I'm just trying to clarify for myself. Is it only to me that there is an audio issue, or
there. Even I can hear
is
you.
everyone else able to listen to my talk?
Somebody's mic is on.
Hi. Can please someone just see whether if or someone can probably. Okay, so I think it's just with me. Ma'am, please you continue. I'll work with the.
Sure. So first, I would just introduce these acts. I'll go through the history of these acts, and then I'll go section wise, and then I will move on to the constitutional infirmities and the issues that we have raised before the Supreme Court of India. So to start with, as we all know that infertility has been classified by the WHO as a disease and it's not a disorder anymore. And it is known to affect around 13 to 19 million people in India at any given point of time. Given the huge numbers, assisted reproduction, which consists of in vitro fertilization, IUI, which is intrauterine insemination, and surrogacy, are one of the wonders of modern science that has come to the rescue of all these childless couples who are desperately in need of a child. And so But the problem was, with the emergence of modern science and these assisted reproduction, there was the scope of misuse. So there was a need for regulation. Going to the history, the first IVF baby was born in Calcutta in the year 1978. Then commercial surrogacy, which uses a third party, that is a surrogate mother, to lend her womb to beget a child, was legalized in India in 2002, which eventually led to several foreign nationals seeing India as a hub of assisted reproduction and surrogacy at affordable prices. Rising demand led to intermediaries and agents, and which also raised concerns about exploitation of women. Then there were cases like Baby Manji, in which a Japanese couple had used a surrogate mother from India, which raised certain citizenship issues of the baby, because before the baby could be delivered, the Japanese couple got divorced, and because the mother was an Indian surrogate, the baby had Indian citizenship. So there was problem with citizenship, which raised concerns regarding proper guidelines in regard to surrogacy and ART. That led to the ICMR passing guidelines for assisted reproduction and surrogacy in the year 2005, which were being followed for all these years. Later, there was a PIL filed by Ms. Jayashree Wad, in which the central government placed an affidavit that they will be coming up with a legislation very soon. Eventually, in 2016, the Surrogacy Regulation Bill was laid before the Parliament. There was the 102nd Standing Committee report to this 2016 Surrogacy Regulation Bill, which made some important observations. The first was that the bill does not include single women, single men, same-sex couples, and live-in couples. The second concern was there should be a provision for compensation for a surrogate mother. So what they were asking for is, while commercialization is more about profit making, compensation is restitutionary in nature, and not having any compensation for a surrogate mother in turn may lead to exploitation of the surrogate mother. So it may lead to a bigger harm than it was, intended to mitigate. However, none of these suggestions were taken into account in the 2019 bill, which was later passed as the Surrogacy Regulation Act and the ART Act. So now I would like to come to the Act, and I'll go through certain definitions and provisions of the Act. So the laws relating to assisted reproduction have been classified into two parts. The first is the Assisted Reproductive Technologies Act 2021, which mostly deals with the medical and scientific aspects of it. And second is the Surrogacy Regulation Act, which deals with the ethical aspects of surrogacy. So now let's go into the Act. I will go section wise. I'll just go through some definitions first, and then I'll start explaining. So the Surrogacy Regulation Act was passed on 25th December 2021, and it came into force on 25th January 2022. We go to the statements of objects and reasons. It says it is an act to constitute National Assisted Reproductive Technology and Surrogacy Board, State Assisted Reproductive Technology and Surrogacy Board, and appointment of appropriate authorities for regulation of the practice and process of surrogacy, and for matters connected therewith and incidental thereto. Now the definitions are in section 2 of the Act. Section 2, clause B defines altruistic surrogacy. So right now we have the altruistic surrogacy model in India as per the Act. So altruistic surrogacy means the surrogacy in which no charges, expenses, fees, remuneration, or monetary incentive of whatever nature, except the medical expenses and such other prescribed expenses. Now they have not clarified what these other prescribed expenses should be, incurred on surrogate mother, and the insurance coverage for the surrogate mother. are given to the surrogate mother or her dependents or representative. So this is how they have defined altruistic surrogacy. Now we'll go to clause G, which defines commercial surrogacy. Commercial surrogacy means commercialization of surrogacy services or procedures or its component services or component procedures, including selling or buying of human embryo or trading in the sale or purchase of human embryo or gametes, or selling or buying or trading the services of surrogate mother. So it's mostly about selling, buying, trading the services of surrogacy, which we call as commercial, by way of giving payment, reward, benefit, fees, remuneration, or monetary incentive in cash or kind to the surrogate mother or her dependents or representative, except the medical expenses and such other prescribed expenses incurred on the surrogate mother and the insurance coverage for the surrogate mother. So even the definition of commercial surrogacy says that there is a provision for medical and such other prescribed expenses which have not been defined in the Act. Although when we go to the parliamentary debates and the select committee reports, this term, other prescribed expenses, has been added to this Act after due deliberation and discussion of incorporation of a component of compensated surrogacy in the Act. But the Act nowhere uses the word compensated, compensation. The only two words that it uses is altruistic and commercial. It's causing a great deal of confusion. So this is about altruistic and commercial surrogacy. Moving on, we'll go to the definition of an intending couple. An intending couple means a couple who have a medical indication necessitating gestational surrogacy and who intend to become parents through surrogacy. Now, let me make it clear now that the Act, as it stands today, allows only gestational surrogacy. That means the sperm and ovum are fertilized outside and then they are implanted in the womb of the surrogate mother. The surrogate mother cannot provide her own gametes, which was the traditional surrogacy method. Section 2S defines intending woman, means an Indian woman who is a widow or divorcee between the age of 35 to 45 and who intends to avail surrogacy. So section 2R and S now say that who all can avail of surrogacy. So it says that a married couple can avail of surrogacy within a certain age bracket, and a single woman can avail of surrogacy if she is a divorcee or a widowed woman between 35 to 45 years of age only. Apart from that, no other single woman or man can avail of surrogacy as per the new Act. Again, the Act has the national board which implements the Act. It has the state boards. It has the national registry. I would not go into the details of that right now. Then I will take you to the definition of the surrogate mother under section 2ZG. Surrogate mother means a woman who agrees to bear a child, brackets, who is genetically related to the intending couple or intending woman, through surrogacy from the implantation of embryo in her womb and fulfill the condition as specified in subclause B of clause 3 of section 4. So this particular definition of surrogate mother was still recently creating a lot of confusion, that a surrogate mother has to be genetically related or a close relative of the intending couple or the intending woman. This is because the language of the section was very ambiguous, because under brackets, the genetically related term, it was not clear whether it applied to the surrogate mother or to the child. But recently, the Union of India has given a clarification on the last date of hearing before the Supreme Court, stating that the surrogate mother need not be genetically related to the intending couple or intending woman. It's the child that has to be related. Although that is another contentious issue that we'll come to later, but this is about the definition now. Then we go to section 3 prohibits advertisement of commercial surrogacy in any form, and there are punishments for that as well. Now we'll go to section 4, which is very important. So section 4, subsection 2 says that no surrogacy or surrogacy procedures shall be conducted, undertaken, performed, or availed of, except for the following purposes. Now, this is very important. Number 1, when an intending couple has a medical indication necessitating gestational surrogacy. Provided that a couple of Indian origin or an intending woman who intends to avail surrogacy shall obtain a certificate of recommendation from the board on an application made by the said person in such form and such manner. For the purposes of the said clause, the expression gestational surrogacy means a practice whereby a surrogate mother carries the child for the intending couple through implantation of embryo in her womb, and the child is not genetically related to the surrogate mother. So this is what they have explained gestational surrogacy to be. The child does not have to, cannot be genetically related to the surrogate mother, as was the case in traditional surrogacy. The child has to be related to either of the intending couples. The second condition is that it is only for altruistic surrogacy purpose. Third, when it is not for commercial purposes or for commercialization of surrogacy or surrogacy procedures. D, when it is not for producing children for sale, prostitution, or any other form of exploitation. And D, any other condition or disease as may be specified by regulations made by the board. So now this clause 4, section 4, clause 2 says that the surrogacy has to be for altruistic purpose. It cannot be for commercial purposes. It cannot be for producing children for sale, prostitution, or any other form of exploitation, which means that the spirit of the act is mostly altruistic. What altruistic means? That it is out of love and affection, out of a will to help another person. This act does nowhere state that the surrogate mother does not have to be compensated for all the efforts that she's putting through. 9 months raising a baby in her womb, going through the whole procedure of pregnancy, all the medicines, visits to doctors. It does not prohibit that. But because it is nowhere using the word compensation or compensated, and the only words that it's using is altruistic and commercial. So even compensated surrogacy is not being allowed in India, even though it has been envisaged in the Act by saying that other prescribed expenses are permissible under the Act. I'll be coming to that later again. Again, the section 4, clause 3 states that an insurance coverage of such amount and in such manner as may be prescribed in favor of the surrogate mother for a period of 36 months, covering postpartum delivery complications from an insurance company agent recognized by the IRDA. So it provides for insurance for 36 months and no provision for compensation. Let me make it clear that insurance and compensation are not the same thing. Then clause B then states, the surrogate mother is in possession of an eligibility certificate issued by the appropriate authority. So to act as a surrogate mother, the surrogate mother has to have this eligibility certificate, which she needs from the appropriate authority set up by the board, on fulfillment of the following conditions. So these are the conditions that a surrogate mother has to adhere to. No woman other than an ever married woman having a child of her own between the age of 25 to 35 years on the day of implantation shall be a surrogate mother or help in surrogacy by donating her eggs or oocytes or otherwise. So the woman has to be ever married. She has to have a child of her own, and she has to be between 25 to 35 years of age on the day of implantation. This is the first condition for a woman to be a surrogate mother. Second condition is a willing woman. That's very important. She has to be a willing woman, shall act as a surrogate mother and be permitted to undergo surrogacy procedures as per the provisions of this Act, provided that the intending couple or the intending woman shall approach the appropriate authority with a willing woman who agrees to act as a surrogate mother. So the only conditions that the Act imposes are that the surrogate mother has to be a willing woman. She has to be married between 25 to 35 years of age and have a child of her own. So this is the regulation that the Act has already put in place when it comes to a surrogate mother. There later, the Act says that no woman shall act as a surrogate mother more than once in her lifetime, and no woman shall act as a surrogate mother by providing her own gametes. So we see that there are adequate safeguards to protect the exploitation of a surrogate mother by saying that a woman cannot be a surrogate mother more than once. She has to be married, has a child of her own between a certain age group, and she has to be a willing woman. So when all these safeguards are in place, it would not be too much to ask for. If we ask that the surrogate mother is given a certain amount of compensation for carrying the baby. You call it compensation, you call it reimbursement for the other expenses that she has to go through, which includes food, travel, medicines, loss of wages if she is working. Maybe she has to take help from a domestic help for taking care of her own child, since she has to have a child of her own. So provisions of childcare, these things have not been envisaged in the Act. So this is what the government needs to take care of and make specific provisions for. The third is the eligibility certificate for the intending couple. So the intending couple means the couple which wants to go for surrogacy. So there is a age bracket which has been provided for the intending couple. The intending couple are married, number one. They have to be a married couple between the age of 23 to 50 years in case of a female, and 26 to 55 in case of a male on the day of certification. And the intending couple have not had any surviving child biologically or through adoption or through surrogacy earlier. Provided that nothing contained in this item shall affect the intending couple who have a child and who is mentally or physically challenged or suffers from life-threatening disorder or fatal illness with no permanent cure, and approved by the appropriate authority with due medical certificate from the district medical board. So what this act does, it places a restriction on the intending couple to avail of surrogacy if they are below or above a certain age bracket, irrespective of their condition of health. So, and secondly, it does not take into account secondary infertility, in the sense if the intending couple already has one child through surrogacy or adoption or through natural conception, it cannot avail of surrogacy for a second child. So since India does not have a one child policy, this prohibition does not really make any sense in my point of view. Then section 8 talks about deemed biological child. It protects the rights of the surrogate child mostly. A child born out of surrogacy procedure shall be deemed to be a biological child of the intending couple or intending woman, and the said child shall be entitled to all the rights and privileges available to a natural child under any law for the time being in force. So this takes care of the rights of a child born through surrogacy, so that the child does not have any parentage issue, citizenship issues, and the child is deemed to be a biological child of the intending couple, and the surrogate mother has to relinquish all her rights over the child born through surrogacy as part of the surrogacy agreement itself. Then the section 17 sets up the national board. Section 26 sets up the state board. There is the appropriate authority which has been set up under section 35 of the Act. Section 38 deals with offenses and penalties. I'll take you to that. There are stringent penalties which have been provided for the medical practitioners as well as the intending couple, which is unheard of. So, Section 38. No person, organization, surrogacy clinic, laboratory, or clinical establishment shall undertake commercial surrogacy, provide commercial surrogacy or its related component procedures or services, or run a racket or an organized group to empanel or select surrogate mothers, or use individual brokers or intermediaries to arrange for surrogate mother and for surrogacy procedures at such clinics, laboratories, or any other place. So this section mostly prohibits commercial surrogacy and exploitation of surrogate mothers and children born through surrogacy. And Section 39 then says that any registered medical practitioner, gynecologist, pediatrician, embryologist, any person who owns a surrogacy clinic and renders his professional or technical services, whether on an honorary basis or otherwise, who contravenes any of the provisions of this Act, other than the provisions referred to in Section 38, shall be punishable for imprisonment for a term which may extend to 5 years and fine which may extend to 10 lakh rupees. This is the punishment provided for medical practitioners. Section 40 then deals with punishment for intending couples and intending women. Any intending couple or intending woman or any person who seeks the aid of any surrogacy clinic, laboratory, or of a registered medical practitioner, gynecologist, pediatrician, embryologist, for not following the altruistic surrogacy or for conducting surrogacy procedures for commercial purposes shall be punishable with imprisonment for a term which may extend to 5 years and with fine which may extend to 5 lakh rupees for the first offense, and for any subsequent offense with imprisonment which may extend to 10 years and with the fine which may extend to 10 lakh rupees. So we see that there are very stringent provisions for the intending couple and intending woman also for going for commercial surrogacy and not following altruistic surrogacy. Now I would like to now we've just dealt with this Act and the sections. Now I would like to deal with the constitutional infirmities and how this Act is exclusionary in nature. First of all, this Act excludes single men, single women, live-in couples, and same-sex couples from the ambit. Now, single men and single women are allowed to adopt. Single women under the ART Act are allowed to go for IVF, in vitro fertilization. But under the Surrogacy Act, they are not allowed to go for surrogacy. So this exclusionary nature of the Act is making it violative of Article 14 of the Constitution, which we have also raised, which is an important issue that we have raised in our PIL before the Supreme Court also, which the court shall be deciding later after it gets all the inputs from the National Board as regards the procedural infirmities in the Acts. The second part is the inconsistency part, which I'll deal with later when I deal with the ART Act itself. The third is the complete ban on commercial surrogacy, which this Act provides for. So this complete ban on surrogacy is neither desirable nor productive in the present sense, because altruism means the desire to help another couple is too big an ideal to achieve in a country like India, where women are one of the most vulnerable sections of the society prone to exploitation. Apart from that, a woman has to go through 9 months of pain, and not recognizing her sacrifice and honoring her sacrifice is another form of exploitation, which the legislators have failed to take into account while legislating this Act. The Supreme Court has, in the case of recently in the MTP judgment of X versus Principal Secretary, has held that reproductive autonomy is one of the aspects of Article 21 of the Constitution. And it is the duty of the courts to provide reproductive autonomy of women. Again, in the case of K.S. Puttaswamy versus Union of India, the court held that right to privacy and bodily autonomy is a fundamental right. In Joseph Shine, which was 2019 3 SCC 39, Joseph Shine versus Union of India, the court, while taking note of the change in social, cultural, moral, and economic values, held how an unhappy marriage is tackled, which it is a matter of privacy. And the law was held bad for not being gender neutral. Joseph Shine was the case which decriminalized adultery. So we see that the courts have been moving towards a trend of progressive interpretation of the constitution, what we also call as transformative constitutionalism. The main legal issue that is here before the court is whether social morality can prevail over constitutional ethos of equality, reproductive autonomy, and privacy. And this is the point that the court has to decide. And this is not something that the national board can take any cognizance of. And that is what we are there before the Supreme Court. Now, next, I would just like to go to the ART Act. We have already dealt with the Surrogacy Regulation Act. So the Assisted Reproductive Technology Act, which is another wing of these acts regulating assisted reproduction, which mostly deals with the technical and scientific aspect. So the statement of objects and reasons states that it is an act for the regulation and supervision of assisted reproductive technology clinics and the assisted reproductive technology banks, prevention of misuse, safe and ethical practice of assisted reproductive technology services for addressing the issues of reproductive health, where assisted reproductive technology is required for becoming a parent or for freezing gametes, embryos, embryonic tissues for further use due to infertility, disease, or social or medical concerns, and for regulation and supervision of research and development and for matter connected therewith and incidental thereto. Coming on to the definition part, Section 2E defines a commissioning couple. So a commissioning couple means an infertile married couple who approaches an assisted reproductive technology clinic or assisted reproductive technology bank for obtaining the services authorized for the said clinic or bank. Again, even in the Assisted Reproductive Techniques Act, a commissioning couple has to be a married couple. So they are not recognizing other couples like a live-in couple, which has been very much recognized by the Supreme Court, and even child born in a live-in couple have been given constitutional rights. It is not recognizing same-sex couples, even though homosexuality has been decriminalized in Navteej Singh case. Although it has not been given legal, same-sex marriages have not been recognized till day, but the Supreme Court is considering that as well. But even the Assisted Reproductive Techniques Act is exclusionary in that sense, since it does not recognize a single man, live-in couples, and same-sex couples as eligible for going through assisted reproduction, that is in vitro fertilization. Again, the ART Act also has the National Board, State Board, and the National Registry, which is common with the Surrogacy Regulation Act. So I would not go into that. It defines a woman under Section 2U. So a woman means any woman above the age of 21 years who approaches an assisted reproductive technology clinic or assisted reproductive technology bank for obtaining the authorized services of the clinic or bank. So this act is permitting a single woman to avail of IVF services, which is in contradistinction to the Surrogacy Act, which completely bars single women for going through surrogacy. Next, we'll go to the important provisions under Section 21 of the Act. Chapter 4, which deals with duties of assisted reproductive technology clinic and assisted reproductive technology bank. So this act now has an ART bank and an ART clinic, which have different duties, which I'll come to now. The clinics and banks shall perform the following duties, namely, the clinics and banks shall ensure that commissioning couple, women, and donor of gametes are eligible to avail the assisted reproductive technology procedures subject to such criteria as may be prescribed. The clinics shall obtain donor gametes from the banks, and such bank shall ensure that the donor has been medically tested for such diseases as may be prescribed. So now what this act has done, that it has created a separate donor banks, and it has made it mandatory for clinics to obtain donor gametes from these ART banks and then process them for IVF or whatever other process that they have to go through, which is an unnecessary procedural requirement, I feel, and it will just lead to wastage of time, because these art banks don't have the expertise or infrastructure to retrieve gametes from donors. The necessary expertise lies with the clinics. So these art banks are just unnecessarily causing a lot of confusion and delay in retrieval of donor gametes, and they could just be done away with, which we have also raised in our petition before the Supreme Court. Again, Section 21G provides that the clinic shall apply the assisted reproductive technology services to a woman above the age of 21 years and below the age of 55 years, and to a man above the age of 21 years and below the age of 55 years. Sorry, for a woman, it is 21 years and below age of 50 years, and to a man above the age of 21 years and below the age of 55 years. So this provision is also problematic. Firstly, that is, it is inconsistent with the age bracket given in the Surrogacy Act. Now, let me tell you that ART Act, the Assisted Reproductive Technique Act, is the umbrella legislation, and surrogacy comes under that. Out of all the assisted reproductions, 98% consist of IVF, which come under the Assisted Reproductive Technologies Act, and only 1% of them go for surrogacy under the Surrogacy Regulation Act. So it is important to harmonize the two acts so that they can function properly. In the ART Act, the age restriction for a woman is 21 to 50 years. In the Surrogacy Act, it is 23 to 50 years. So while a woman can go for an IVF when at the age of 21, she has to wait for another 2 years to go for surrogacy services, which does not make any sense, and it is completely inconsistent with the object of the act also. Secondly, for a man, the age limit under the ART Act is 21 years to 55 years. And in the Surrogacy Act, it is 26 years to 55 years. So again, there is lack of harmony there as far as age is concerned. The second issue is that while in a surrogacy, it is both the parents that are actually involved. In an IVF, it is usually the woman whose body is taking in the embryo and who's going through all the procedures. So this upper age limit for a man is really not making any sense, because it is the woman that has to be healthy at a certain to go for IVF procedures, and the man's age wouldn't really matter in this case. Also, because you are also allowing a single woman to go for IVF. So when you are allowing a single woman and when a couple comes to you, you are imposing these unnecessary age restrictions on them, which is also a violation of Article 14 of the Constitution. In fact, the Kerala High Court has recently directed the central government to have a relook on this upper age limit for a man to avail of an IVF services, as they say that this has been incorporated in this act without having any transitional provisions, which means that before the enforcement of the act, people had already started processes. They had frozen their embryos and gametes. And now suddenly these acts have been rendered illegal after the coming into force of the act, and these people who are above a certain age bracket have been excluded. So the act should have had certain transitional provisions for a smooth functioning of the gametes or the embryos which had already been frozen prior to the coming with the force of the act, which has not been taken into account. Also, most of the parliamentary debates and select committee recommendations say that they say nothing about the upper age limit of a man. In fact, they say nothing about the upper age limit at all. They say that there should be a minimum age limit to go for surrogacy and IVF, and the upper age limit should have been left to the discretion of the doctors depending on the health of the patient. So the state imposing these age restrictions arbitrarily is a matter of concern, and it has been raised in our PIL before the Supreme Court also. Then the Act provides for insurance coverage for under Section 22B. It says that the clinic shall not perform any treatment or procedure without an insurance coverage of such amount as may be prescribed for a period of 12 months in favor of the oocyte donor by the commissioning couple or the woman from an insurance company or an agent recognized by the IRDA. So what we have to see here is that even the ART Act provides only for an insurance coverage. And even though it does not specifically bar compensation in favor of an oocyte donor who's coming to donate the oocytes or sperms, it does not provide for the same. So there is no provision for compensation for these egg donors or sperm donors provided under the Act, which will eventually lead to a severe shortage of egg donors and sperm donors in our country. And considering the numbers that I spoke about, 13 to 19 million, the number of people that will eventually be affected by this shortage is huge. And so the government should consider having some amount of compensation for these oocyte donors and for the sperm donors as well, since it has not been specifically barred under the ART Act for IVF, as it is in Surrogacy Act. Next, we are going to Section 25. Section 25 says that the pre-implantation genetic testing shall be used to screen the human embryo for known pre-existing heritable or genetic disease only. So there is a pre-implantation genetic testing here provided for in the Act for genetic or heritable diseases. The donation of an embryo after pre-implantation genetic diagnosis to an approved research laboratory for research purpose shall be done only with the approval of the commissioning couple or woman, and when the embryo suffers from pre-existing heritable, life-threatening, or genetic disease. The National Board may lay down such other conditions as it deems fit in the interest of the pre-implantation genetic testing. So pre-implantation genetic testing has been allowed in the Act. What has been prohibited under the Act is provided under Section 26, is sex determination. Subject to the provision of the preconception and prenatal diagnostic techniques, Act 1994, the clinic shall not offer to provide a couple or woman with a child of a predetermined sex. It is prohibited for anyone to do any act at any stage to determine the sex of the child to be born through the process of assisted reproductive technology, to separate or yield fractions enriched in sperms of X or Y variation. So just let's not go into the technicalities, but basically the Act is prohibiting sex determination in case of assisted reproduction, which is a very good move. Now we next moving to sourcing of gametes. So how they are sourced, it is provided under Section 27. The screening of gamete donors, the collection, screening, and storage of semen, the provision of oocyte donor shall be done only by a bank registered as an independent entity under the provision of this Act. So, as I had said earlier, the task of screening of gamete donors, collection, screening, storage of semen, provision of oocyte donor has been given exclusively do a donor bank, which has to be registered as an independent entity. Now, whether these donor banks have the necessary expertise or infrastructure for this process is not really clear. Secondly, till date, not a single ART bank has been set up in the country. And even though the ART clinics are very much capable of screening and retrieval of oocytes and gametes, they are unable to do so owing to this bar under Section 27. So this has basically brought the entire IVF cycles through third-party donors in the country to a standstill. So this is a very problematic provision that needs to be looked upon. Second is the age limit again given. The bank shall obtain semen from male between 21 years of age and 55 years of age, both inclusive, and obtain oocytes from females between 23 years of age and 35 years of age. So this age limit is basically given because this is the age wherein the healthiest of oocytes or sperms can be obtained from males and females respectively. So that is why this age restriction must have been incorporated in the Act. Section 27(3) states a bank shall not supply the sperm or oocyte of a single donor to more than one commissioning couple. So we see that this Act has made adequate provisions to prevent exploitation of these oocyte donors, sperm donors, and also to prevent commercialization and parentage issues later. If the same sperm or ovum is supplied to more than one commissioning couple, then there may be other problems arising. So this Act has tried to prevent that. Section 27(4) provides that an oocyte donor shall donate oocytes only once in her life, and not more than 7 oocytes shall be retrieved from the oocyte donor. Now, this provision we have challenged as being scientifically handicapped, first of all, and it is also against international best practices. The first part, which says that an oocyte donor shall donate oocytes only once in her life. Firstly, there is no scientific backing to prove that donation of oocytes has any short or long-term health risks. In fact, in most countries which allow oocyte donors, they allow 3 to 10 times, and 6 is the average, which is as per the American guidelines, with no short-term or long-term health implications. Moreover, if we just restrict oocyte donors to donating once, it will again lead to a very severe shortage of egg donors in the countries, since there is no provision for compensation as well. The other part, which says that not more than 7 oocytes shall be retrieved from the oocyte donors, this is also medically and scientifically impossible to implement, because when even with the lowest dose of ovarian stimulation is what we call the term, when we have to retrieve an oocyte, around 9 to 15 oocytes are retrieved at any given point of time. In fact, for the best live birth rate, the number of oocytes which need to be retrieved is proven to be 15. So this restriction of not retrieving more than 7 oocytes will really not serve the purpose of having a live baby, which is the whole purpose of having an IVF. And this 27(4) should be struck down as being unconstitutional and unscientific, because it is not just medically unviable, but it is also restricting an oocyte donor to donate her eggs, which is part of a reproductive autonomy, which has been provided under Article 21 of the Constitution. So this is about Section 27, which has certain constitutional issues as well. Then there are punishments provided for doctors under Section 33 of the Act. It says that whoever contravenes the provisions of Clause A to G shall be punishable with a fine which shall not be less than 5 lakh rupees, but which may extend to 10 lakh rupees for the first contravention, and for subsequent contravention shall be punishable with imprisonment for a term which shall not be less than 3 years, but which may extend to 8 years, and fine which will not be less than 10 lakhs, but may extend to 25 lakhs. So this quantum of punishment is really unheard of before. In fact, doctors are being treated as criminals in case of assisted reproduction and surrogacy. Recently, the Honorable Supreme Court in X versus Hospital, in X versus Principal Secretary, which is the MTP judgment, had highlighted how this fear of prosecution has a chilling effect on medical practitioners, and it blurs their judgment. So this unnecessary penalty and bringing doctors under the rigors of the IPC is really not serving the purpose. In fact, the doctors are now scared of even undertaking legal procedures under the act, because even for minor procedural ambiguities, they may be sent to jail or they may be fined for up to 25 lakh rupees. Also, doctors already are under the purview of civil courts, under consumer courts, under the National Medical Council. So there is no need to import the provisions of IPC into a field which is so technical and so scientific. And so this section should also be held as unconstitutional, which we have also raised in the petition. So that's all about ART Act. So in a nutshell, what we are trying to put before the Supreme Court as is that although a regulation is required in this field, because there is a scope of misuse and exploitation, but the legislation should be an enabling legislation. It should not be a restricting legislation as it stands now. Make it enabling with adequate checks and balances, so that childless couples are getting what they need and what they hope for, and they can avail of the benefits of modern science and assisted reproduction, and at the same time protect the rights of surrogate mothers, the child born through surrogacies, and any other unethical practices in this field. So that's what it is about. So I would just like to end my lecture here. If you guys have any questions regarding that, I'm open to that.
Ma'am, thank you so much for such wonderful enlightenment on this very unique topic. And I'm quite sure that there is a lot which needs to be processed by everyone, which I think will
Yes.
keep on happening with time itself. So once again, I very warmly welcome everyone who has joined us after we started. It's really wonderful to have your distinguished company. VJK sir, hi. I think you have a question, sir. Sir, your mic is on mute.
Actually, I have already given a message in the chat box addressed to the co-host, Madam Mohini Priya. No?
Yes, sir.
Perhaps she can read that. And in fact, this law, Act of 2021, perhaps may not be applicable to various communities and tribes residing in this country, especially to our Khasi community, Khasi and Jantia community. You will notice that we are a matrilineal society, unlike patrilineal or patriarchal society. Here we don't accept adoption per se. Adoption, the law of adoption is not applicable. We have a custom which we call it rapying. If you look at the chat box which is addressed to you, yes. I have posed that question. Rapying, RAP-IING, rapying. It's a very interesting term. Meaning, suppose there is no more female line. Suppose that a woman who's the youngest, who's a khaddo, the youngest daughter of the family, she does not have issues. And because here, when we talk about the Khasis, we have got this law of inheritance. And inheritance per se will have to be from the female line. Now, suppose the couple don't have any children issues, then we have a custom. We have a custom called Rabieh, not adoption from any other families. It has to be an adoption from that female line of the woman or of the mother of this daughter who's issueless.
Okay.
So, according to me, I feel that this particular law, surrogacy law of 2021, perhaps the Supreme Court will have to be apprised that it cannot be universally applicable to all of us, because I understand that I was noting that definition, section 2 must be 2I, 2 bracket I bracket ZG, which speaks about surrogate mother need not be genetically related to the child.
Yes.
But the child must be genetically related to the intending couple. I think something like that. Actually, I was listening to you on a few other lines, and this came to my mind. Perhaps from your end, you can raise this point, because I've given you that in that chat box.
Yes.
You can place that. I mean, you can find a way how to intervene in that, or put a note, perhaps to the Registrar General of the Supreme Court, that this point, so far the Khasis and judges is concerned, perhaps this law should be exempted. We will never accept a child born of a surrogate mother. That's according to me. Well, this law of surrogate mother, I mean, this Act of 2021 per se, it's an important law. We cannot deny that it's not an important law. But I think that, Indian society, I mean, especially the Hindu society, I feel that it is a little bit opposed to our system. When you look at Europe and other countries, they don't have this family thing, that close-knit family. They don't have that system. I've noticed with my relatives who are in the US or Europe, they don't know their next door family. They don't have this. They don't know the female line, the uterine line from the mother side, neither from the father side. They are just cut off. They are a single unit. But when you look at Indian societies, it is not like that. And Mohini ji, thank you very much. And,
thank you, sir. This is a very important input that I've got from you, and I'll certainly raise this.
Acha, I just want to know, you are practicing where?
I practice in the Supreme Court.
Very good, very nice.
I'm an AOR. Yes.
Thank you, thank you. And I'm very happy to Mrs. Sharma for bringing out all this type of project, which is very helpful. And I think it should be publicized more further. Thank you, thank you.
Thank you.
It's a blessing that you spare such valuable thoughts, and I'm quite sure that Mohini ma'am has received the brief, the gist of what you've communicated, and it's a very important and valid point which the Honorable Court has to decide before moving further in this.
Yes, I think it has to be brought. The Supreme Court has to be apprised, and even the center need to be told that in the areas covered by Article 244, Clause 2 of the Constitution of India, that means the 6 scheduled areas, perhaps these type of laws which are opposed to our societies should be exempted right at the threshold. There must be some provision in that Act of 2021 to exempt this law to these areas, especially when you look at the Part 9 of the Constitution of India. You'll notice that the Panchayati Raj is exempted from its application to the areas under Article 244, Clause 2 of the Constitution of India. Thank you.
Much to learn for us, sir, from you still.
Hello.
Yes.
Hello, Keshav.
Yes, Sanjeev ji, please.
Can I ask
But
my
Sanjeev ji,
question?
all right, Sanjeev ji, before you start, very humbly, I want to submit that you have a lot of questions, right? So you please break them down one by one, and then you ask, ma'am, you give her the opportunity to answer also, and then
I've
you
written
ask
in
the
my chat.
second.
I've written in my chat one by one. I've numbered them. Keshav, just
Okay,
read it
Yeah,
yes,
out
I
to
can
ma'am, no?
see.
yeah.
Keshav, just read it out
Would you
to
want
ma'am, no?
me to ask, or do you want?
Yeah. If you ask, it will be better.
Okay, then I will ask, and you please just patiently wait for the
Yeah,
answer. Okay.
yeah.
So, ma'am, the first question which Sanjeev ji has asked is, the
Yes.
board is saying that the child of a single man or woman will not
Hmm.
be accepted by the society.
Hmm.
Article 21 says that everyone
Child
has
of
the right
single
to,
men and women. No,
will not be
board is not.
accepted.
Okay, matlab surrogate child.
Single
Yeah.
man or woman will not
Yes.
be accepted by the society.
Hmm.
And Article 21 says that everyone has the right to life, liberty, and
Yeah.
freedom.
Hmm.
If the board decides whether single person should not have child because of fear of not being accepted by the society, then where is the right to life?
Yes, that is why we are before the Constitutional Court. Because if the board decides against it, then the Supreme Court has the power to decide on the constitutionality of that decision as well. Since these people, single men and single women, their rights have very much been sealed by the Supreme Court. Single men can adopt, single women can adopt. And it has been proven that single men and single women can raise child as good as a couple or even better.
So,
So
ma'am, is
why
it not
just
contradictory? Is it not contradictory? In adoption, it is being allowed, and here it is not being allowed.
yes. It is.
Here it will be my offspring of my genes and chromosomes. In adoption, it is a third party child. So everyone,
You
it is
can't
not a
force an
universal
adoption.
solution.
It's
The adoption
indirectly
is not a
forcing
universal
adoption.
solution for everyone.
Yes. No, I agree with that point, and we have raised that point. But the court will decide on those issues only after it gets the inputs from the national board as regards the provisions of the act. So beyond the act, the court will decide only after that. So
Yeah.
these are all constitutional issues which have to be raised and which will be argued later. Yeah.
All right. So I'll take you to the second question now.
Yeah.
Second question from him is, embryos have been freezed by many single men and women before January 25th, 2022, which were ready to be transferred into healthy surrogate. What will happen to them now, especially single people whose cutoff limit is coming in the end, or people who just
Correct.
close to
Yeah.
the age limit mark?
We have this ad interim relief that you're talking about. We have already filed an application seeking ad interim relief for embryos which have been frozen before January 25th. And also for all the procedures that have been started prior to the coming into the force of the act may be allowed to continue in the absence of transitional provisions. But the court will hear it only once it gets a response from the national board. Because this
But
is
ma'am,
very
till the board
on a
decides, the cutoff
case-to-case
limits will be
basis.
over. The cutoff limits will be,
I
people
know.
must have
On a
crossed 55 years
case-to-case
of age.
basis, people are approaching the high courts and getting orders. But Supreme Court is kind of hesitant here in passing orders in this regard.
Then, ma'am, extension may be asked for at least 1 year or 1.5, because to complete 3 cycles, it at least takes 3 months to complete one
Yes.
cycle. So 3 cycle will take 9 months or 1 year. So that also should be asked in the ad interim relief, that at least when the board has stopped and they have wasted the 1 year of single men and women,
Yes.
1 year, 1.5 year extension may be given, 1 or 2
Yes.
years, because during COVID also 3 years have gone.
So that's a good point.
Open.
I have noted this point for extension.
Acha, third point, they are talking about commercialization. So, ma'am, they can regulate the commercialization. How much a doctor will charge, how much a surrogate will charge, how much a donor will charge. That the board can regulate. How in T20 matches the board has regulated, and how people, I mean, the charges are fixed and all that. So board can regulate that commercialization. In kidney transplant also, there is this rackets going on and all that. How government is controlling them. Multiple organ failures are there, so multiple transplant are being allowed, multiple organ transplant. So here also a similar logic may be applied, ma'am.
Definitely, that's why we're asking for compensated surrogacy model, which is being followed in most parts of the world. So in compensated, the board can fix an amount, and since other aspects have already been regulated, fixing an amount will cause no harm. It's not
So kindly,
equivalent
ma'am,
to
note that.
commercialization.
So kindly, ma'am, note that if they are talking
Yeah,
about
that
commercialization.
we already have in the petition, and it is being taken up.
Okay.
Yeah.
And one last thing, ma'am.
Yeah.
One last thing. We have filed a written argument. We have filed a written argument, and a pill inward number is 4309 SCI pill E 2023. It is under process, and we have asked them to club it or tag it with your application, and we have
Where
done
have you
twice. So
filed
twice they have not done.
this?
We
You
have
have
done
filed
in
a
22.
PIL.
Yeah. Written argument we have filed because we cannot come to Delhi.
Sanjeev, what
Yeah.
we'll do is,
Yeah.
we'll fix up a time for you and ma'am to have a discussion. Probably,
Just let me finish, ma'am.
considering you have very specific
Yeah. It
thoughts
is
and
okay.
inputs towards this,
But
that
just
some
let me
maybe,
finish.
Sanjeev,
Uh,
just a second, please.
uh-huh.
Some may be beneficial for her to shed light on her arguments also, and you may also get some clarification with respect to what you have in your mind. So absolutely, it's really wonderful that you are so devoted and concerned towards this.
Yes.
But I think it will be better to have a proper conversation in this.
Just read my point 3 and 4.
Yeah. No,
just read
it's
that,
all done. It's on record only, and we'll keep it and we'll also share it with ma'am also.
I will,
So that she
definitely,
can give
I'll go through it.
clear consideration in that.
Yeah. So just club it with your application, and we are in strong support with you. I mean, so either club it. Maybe they won't tag the application. We are not certain whether they will tag or not. So you just club my application with yours. I've sent all the soft copies and hard copies to Keshav, so he will give you everything, ma'am.
That will be great.
My request is only that.
Yeah, thank you for that.
Absolutely, Sanjeev. Absolutely, we'll do that. And very
Thank
kind
you,
of you to extend your support to ma'am also. I'm quite sure that she's fighting this battle right now, and it will be important for her to know that. So, as far as just one point I want to further clarify, I think with respect to what was mentioned that people who have, who are already in the process, I think the Honorable Court also on the last date of hearing also mentioned that such people who are already in the process or who are here, that we may choose to give some extension, but that will be obviously discussed at a later stage, and ma'am will be knowing better about what and how and when and where. So with respect to that, again, bringing everyone back to the topic that if there are any questions which anyone else also has in their mind, which they may choose to ask, I think right now is a wonderful opportunity. All right. So again, please, everyone, I'll just ask one question which I want to ask, and in the meanwhile, whatever other questions are there, either please feel free to share in the chat or to directly, just unmute and ask at the appropriate moment. So, ma'am, one consideration and one thought which I have, and it's more of an opinion only from your perspective, that what do you have in this respect? That how society is being structured today or how it is being guided, as you mentioned during your session also, that homosexuality is being accepted, outrightly by the court, that they're giving it legal sanction. At the same time, there are other elements such as live-in relationships. So those are also being now looked at by the court as effective representation of the society. Now, similarly, ma'am, for all of these people who probably, let's assume, okay, live-in relationship is still one, relationship which does not have the sanction of law as a marriage. Similarly, any two people who choose to be in a homosexual relationship, considering that there is no opportunity for them today to obviously be getting married here in India. So, what is the scope for them to for progeny? Is there any, or is it like outrightly that they just cannot have a child of their own through surrogacy and IVF in the current context?
As per this act that it stands today, they have been completely ousted. They cannot go for an IVF, neither for surrogacy. So the only option that they have is adoption. In fact, I think the government is just trying to force adoption on those people that, why not adopt? Why do you want to have a child of your own genes? But this is again a violation of their constitutional rights as well. So the court will have to take these issues up, especially because homosexuality has been decriminalized. Same-sex marriages are under consideration now, and court has recognized relationships in the nature of marriage. which may include the same-sex couples, the live-in couples, and other people which are in the nature of marriage. And the children born out of such couples are also given legal recognition. So why not surrogate children, and why not babies born through IVF? Only females can go through, but for men, same-sex men, it's only surrogacy. That's an option from
So,
which they
ma'am,
have been completely ousted.
There is this very strong, I will say, how everyone, you've also worked extensively in the field of women's rights. There is this huge new jurisprudence which I think is on the verge of the boil, which is for male rights, for men's, what exactly is a man's concept of living.
Single men have been completely ousted from both the acts. While in ART Act, single women have some rights, but single men have not been considered anywhere. Which is,
be it divorced also, they still don't have any rights.
Yes, they don't have any rights, which is absurd. So these acts definitely need a relook from a statutory as well as a constitutional point of view. So let's see. So,
I'm considering that there are no further questions which have come, but I'm quite sure that there is a lot to be discussed in these topics, which obviously we're grateful to you for championing the thought and taking it forward and extending your fight. Best wishes and all the support from all of our team and all of our participants.
Thank you so much for having me here.
I thank you on behalf of everyone who has participated and people who are going to watch this on YouTube. So, we hope for the best for your cause, that you obviously thought of this battle and you're championing it.
Yes, and it's a joint cause. So
yeah, we're just grateful to you for thinking about the society, and as you mentioned that the nobility in the profession for working to cherish and represent. So for everyone, thank you so much for participating. It's really
Ma'am, one last thing. Ma'am, when you get the order in the favor of those people who have freezed those embryos, kindly ask for extension in time limit, because some might have exhausted the ages of 55 in men and women. So at least by 1 or 1.5 years, kindly ask for extension. Otherwise, they'll miss the boat only. Even if they win, they'll lose. The doctor will tell them the time limit. You have finished the time limit. So only that request.
All right.
One thing I want to mention to you also, that whatever I have also been able to observe the bench so far, they are extremely diligent with the case. They are aware of the honorable judges who are looking into the matter. They are absolutely to every single detail. They have their attention there. But as ma'am she has also mentioned that it's a very technical law. So there are a lot of technicalities which have to go into place, but whatever best can happen, that will happen. We have such wonderful people championing the cause.
Yeah, but the Supreme Court is very slow. The dates are coming after one month, 4 months.
Procedures have to be followed. Without procedures, there's nothing.
The fertility experts will just show the cutoff limits to the patient. They will say your time is over, you go now.
Yeah.
So what about those people?
So I'll speak to ma'am and I'll probably, with her consent, arrange some time for you to discuss with her also.
Thanks.
At that point of time, you take her time, you discuss whatever you want
in
depth, whatever your petition and whatever your thoughts are also there in that respect. But for now, the time we've already taken enough time from ma'am today, and we're very grateful to ma'am as well as to every single person who has attended. I think Dr. Chiranjeev wants to say something. Sir, hello, welcome.
Hello.
Yes, sir, please.
Hello.
Yes, hello? we can hear you, sir. Please. Chiranjeev ji, good afternoon now.
Good afternoon, sir.
जी सर, नमस्कार.
नमस्कार सर.
सर, कोई सवाल आपका या कोई चीज आप शेयर करना चाहते हैं हमारे साथ?
हम पूरी ज्वाइन नहीं कर पाए थे एक्चुअली, तो वर्क की वजह से. मैं केवल एक ही पूछना चाहता था कि जो ये रूल्स बने हैं उसका इम्पैक्ट, सोशल इम्पैक्ट क्या रहा होगा?
रूल्स इन कोई स्पेसिफिक रूल आप हाईलाइट करना चाहते हो सर?
नो मैम, बस इसका ये हम सोशल इम्पैक्ट जानना चाहते हैं।
देखिए, एक्ट का सोशल इम्पैक्ट तो अभी हमने अभी यही सुप्रीम कोर्ट के सामने पेश किया है कि ये जो एक्ट है ये बहुत लोगों को एक्सक्लूड कर रहा है इसकी बेनिफिट्स अवेल करने से। तो जैसे सिंगल मैन को एक्सक्लूड कर लिया गया है, सिंगल विमेन भी, सिर्फ विडोज और डिवोर्सीज अलाउड है सरोगेसी अवेल करने के लिए। उसके अलावा सेम सेक्स कपल्स, लिव इन कपल्स को कंप्लीटली एक्सक्लूड कर दिया गया है। तो ये जो है ये दिस इज अ वायलेशन ऑफ देयर कॉन्स्टिट्यूशनल राइट्स आल्सो, एंड दिस शुड बी कंसिडर्ड बाय द कोर्ट, and the act should be inclusionary in nature, because the whole purpose of surrogacy is to help people who cannot have a child of their own. So just having a patriarchal proper family to avail of surrogacy is not really serving the purpose of having the benefit of surrogacy in the first place. So this should be extended to single men, single women, and other couples which are not married couples, but which are relationships in the nature of marriage. So this is one of the aspect. The second aspect regarding ban on commercial surrogacy, हम उस पे भी बोल रहे हैं कि completely इसको ban कर देने से कोई फायदा नहीं है। इनफैक्ट फिर होगा ये कि फैमिली में ही औरतों का एक्सप्लॉयटेशन होगा, क्योंकि औरतें तो वैसे भी यहाँ पे कमजोर है इंडिया में। तो उनको 9 महीने तक अगर एक बच्चे को पालना है अपने कोख में और उसके लिए उन्हें कोई भी कॉम्पनसेशन नहीं मिल रही है, कोई भी रीइंबर्समेंट्स नहीं मिल रही है, तो वो एक अलग तरह का एक्सप्लॉयटेशन है, जो कि उससे बड़ा एक्सप्लॉयटेशन। इनफैक्ट जो कमर्शियल सरोगेसी में हो रहा था, तो फायदा जो होता था वो एजेंट्स और इंटरमीडियरीज को होता था। सरोगेट मदर को उतने पैसे नहीं जा रहे थे जिसके लिए ये पूरा एक्ट आ गया है। तो ये जस्ट अ फ्यू केसेस ऑफ celebrity surrogacies and fashion surrogacies cannot really be the guiding light for this act. So that is what we are saying, that there are many people who really need children and who have medical complications, and surrogacy is not just about fashion surrogacy or celebrity surrogacy that are highlighted by the media. This is a real problem which the country is facing, and it should be available to all. It is their right and it is a part of their reproductive autonomy guaranteed under constitution. So
एक प्रॉब्लम्स तो और भी क्रिएट होती है और हमेशा रही है
जी,
जितने भी रूल्स रेगुलेशंस बनते हैं, ठीक है, वो सोसाइटीज में लोअर जो क्लास है, ठीक है, वहां तक उनको या तो पता ही नहीं रहता है, या पर्टिकुलर जैसे एजेंट के थ्रू भी उनको पता चलता है, पूरी बात उनको बताई नहीं जाती या कही नहीं जाती। केवल एक ही इसी लॉ में नहीं, मैक्सिमम लॉ की बात ये चीज कही जाती है। तो उसका ये भी जरूरी है कि ठीक है हम डिसीजन दे देते हैं या कोई चीज का एक अवेयरनेस सिस्टम जो है जिससे कि जान सके,
बिल्कुल,
और इस पे चलाना चाहिए कैंपेन्स के रूप में, कैंपेनिंग के रूप में चलाना चाहिए, ताकि हम ये चीज को जान सके कि भाई उसका इम्पैक्ट क्या पड़ रहा है।
ये एक्चुअली ये सही बात है, क्योंकि मेरे पास भी बहुत सारे पेशेंट्स आते जो मुझसे पूछते हैं कि सरोगेट मदर को कितना कॉम्पनसेशन अलाउड है। तो ये किसी को नहीं पता, क्योंकि कोई एजेंट 25 लाख डिमांड करते हैं, कोई 50 लाख, कोई 30 लाख, बट दैट मनी इज नॉट गोइंग टू द सरोगेट मदर। तो ये तो सिर्फ एजेंट्स को ही जा रहा है, जो कि
एजेंट्स को ही जा रहा है। मिडल मैन की भूमिका इसमें जैसे और जितने भी रूल रेगुलेशंस में होते हैं उसमें मिडल मैन की भूमिका ज्यादा होती है, इसमें भी सेम केस इस तरह कंडीशन होगी। उसके लिए क्या किस तरह का प्रावधान नेक्स्ट मतलब आगे किसी तरह का प्रावधान?
देखिए, प्रावधान तो बन गया है, प्रावधान तो है, एजेंट्स इंटरमीडियरीज को बैन कर दिया गया है एक्ट में। बट प्रॉब्लम है कि इस तरह की चीजों में अंडरग्राउंड मार्केट शुरू हो जाते हैं अगर आप कंप्लीटली बैन कर दो। क्योंकि यार आप अगर बिल्कुल ही कॉम्पनसेशन का प्रोविजन नहीं रखोगे, और लोगों को तो चाहिए बच्चा, it is a need, it is a desperation, so they will ultimately go to these agents only, and they will end up paying whatever they are asking for in an illegal manner also. So the act itself should provide for safeguards so that these agents and intermediaries don't have a role to play, which is an adequate compensation for the surrogate mother, which should be fixed by the national board. I think that should help it.
Okay, thank you, ma'am.
Thank you, sir.
बाकी डॉक्टर साहब ये छोटी मोटी कोशिश हम भी कर रहे हैं यहाँ पर अवेयरनेस बढ़ाने के लिए कि लोगों को पता चले एटलीस्ट क्या है कानून एंड इसके लिए मोहिनी मैम थैंक यू सो मच. At the end of the day, education is the one and only solution.
Definitely.
So, and you are helping empower so many, and we're really very grateful to you for that. Very warm thanks to you on behalf of the entire team as well as on behalf of all of the participants. And with your permission, ma'am, I seek to close the class today.
Bilkul. Thank you so much, Keshav.
Thank you so much
For having me over.
Pleasure.
Thank you, everyone.
Thank you so
and
much.
I have noted all the inputs. It was a very good session, very interactive session, and I have also received some very useful inputs, which I'll be using in my next.
Ma'am, we have sent some soft copies to Mr. Keshav, so please take it from him.
I'll put you
read
through to
applications
ma'am directly.
Definitely, yeah.
Right, and फिर आप करो और बल्कि थोड़ी फीस भी देना मैम को तो थोड़ा मतलब फिर वो ठीक लगता है वो ना फिर क्लाइंट.
अच्छा हाँ लेकिन जब तक आप एप्लीकेशन तो जरा पास ऑन कर दीजिए है ना. आप जो सॉफ्ट कॉपीज मैंने दिया एटलीस्ट वो तो पास ऑन कीजिए.
आप प्लीज अपने रिस्पेक्ट में आप बात कीजिएगा. इट्स वेरी गुड दैट यू आर कंसिडरेट अबाउट दिस पर्टिकुलर टॉपिक, बट फॉर नाउ आई सीक टू वेरी humbly close this class. Thank you so much to everyone. And thank you to all the participants, man. So many comments thanking you also. And तो बच्चों की गाली आ रही है और मैम आपकी ब्लेसिंग है, आप कर रहे हो इस चीज के लिए काम. So
need all your blessings.